this session, we will talk about the court system in India, its structure, powers, jurisdiction, and also some important court procedures that every forensic expert and student must know. Because as forensic professionals, the final destination of our work is not the laboratory, it's the courtroom. What is a court? The term court or court of law refers to a person or a body of persons who have the judicial authority to hear and resolve disputes, whether civil or criminal. The word court originally meant an enclosed place, but today it also means the building, chamber, or hall where judicial proceedings are conducted. Structure of courts in India. So, first thing, India follows a single integrated judicial system. That means we don't have separate sets of court for central and state laws. All courts, from the lowest level to the Supreme Court, are linked and follow the same hierarchy and procedure. At the top, we have the Supreme Court of India, then comes the High Court at the state level, and below them are the subordinate courts or district courts. This structure ensures uniformity. That means whether you are in Kerala or Delhi, the basic system of justice remains the same. Let's start with the top, the Supreme Court of India. The Supreme Court of India is the highest judicial authority in the country. It was established under Article 124 of the Indian Constitution. It's the apex court, the final authority in all legal matters, and its decisions are binding on every other court in the country. It consists of the Chief Justice of India and up to 30 other judges. The Supreme Court acts as the final interpreter of the Constitution. If any law or amendment is found unconstitutional, the court has the power to strike it down. Now, what power does it have? It has different type of jurisdictions. Original jurisdiction, Article 131, directly hears dispute between the government of India and states or between states. Writ jurisdiction, Article 32. The Supreme Court can issue writs to enforce fundamental rights. If any citizen feels their rights are violated, they can directly approach the Supreme Court. Appellate jurisdiction. It is the highest court of appeal. Hears appeals from high courts, whether civil, criminal, or constitutional. Its judgments and decrees are binding throughout India. Advisory jurisdiction, Article 143. The President of India can seek the advice of the Supreme Court on any matter of law or fact. This advice is not binding. Revisional jurisdiction, Article 137. The Supreme Court can review its own judgment to correct errors or mistakes. So basically, if you exhaust all other courts, the Supreme Court is your final stop. Next comes the High Courts, one for each state or group of states. They are established under Article 214 of the Constitution. Currently, India has 25 High Courts. Some states share High Courts. For example, Punjab and Haryana High Courts serve both states and Union Territory of Chandigarh. The largest High Court in India in terms of judges and cases is the Allahabad High Court, Uttar Pradesh. Newly established High Court is Telangana and Andhra Pradesh High Court established in 2019. States without their own High Court are served by neighboring one, example Goa, Mizoram, Arunachal Pradesh and Nagaland. Jurisdictions of High Court include original jurisdiction, directly hears certain matters such as matrimonial cases or company law. Writ jurisdiction, Article 226, can issue writs for fundamental and legal rights. Appellate jurisdiction, hear appeal from lower courts. Revisional jurisdiction, can revise or correct errors made by subordinate courts. Now, below the high courts, we have the subordinate courts, which handle most of the day-to-day cases. They handle most cases, both civil and criminal. Civil courts, district judge or principal civil court of original jurisdiction, handles major civil cases, example land disputes, divorce, property. Subordinate judge or munsif handles lower value or small civil cases. Criminal courts, session judges handle serious crime like murder or rape. Chief Judicial Magistrate handles moderately serious cases. Judicial magistrate first class or second class handle minor offences. Revenue courts deal with property, land, and agricultural revenue disputes. Now let's come to one of the most important terms, jurisdiction. What does it mean? In simple words, it means the authority of a court to hear and decide a case. Without jurisdiction, even if a judge passes an order, it has no legal effect. Type of jurisdictions. Territorial jurisdiction. It's based on geographical area. For example, if a crime happens in Kerala, it will fall under Kerala's jurisdiction. You can't file that case in Delhi. Pecuniary jurisdiction. This one depends on the monetary value of the case. A municipal court can handle small claim cases while higher value civil cases go to the district court. Subject matter jurisdiction is based on the type of case. For example, family disputes go to family courts, labor issues go to labor courts, and narcotics cases go to NDPS courts. Original jurisdiction. When a case is filed directly in a court for the first time, that's the original jurisdiction. Like the Supreme Court hearing disputes between states directly. Appellate jurisdiction. When a higher court hears an appeal from a lower court's decision, that's appellate jurisdiction. For example, if someone is not satisfied with a session court judgment, they can appeal to the High Court. Concurrent and exclusive jurisdiction. Sometimes two courts can hear the same case. That's called concurrent jurisdiction. But when only one specific court can hear it, that's exclusive jurisdiction. Special and forensic relevant courts. Now for us, forensic students, there are certain special courts we must be aware of because these are the courts where forensic evidence is often presented. CBI courts for cases investigated by the Central Bureau of Investigation. NDPS court for narcotics and drug related crimes. POCSO court for crime against children. Family courts for family and matrimonial issues. Juvenile justice boards for offences involving minors. Fast track courts for speedy trials in special cases. So, when you are giving expert evidence in a case, always know which court you are presenting in because each has its own hierarchy and procedure. Now, let's discuss court procedures, especially those relevant to forensic expert and witnesses. This part is governed by Section 137 to 166 of Indian Evidence Act 1872, now replaced by Sections 142 to 173 of the Bharatiya Sakshya Adhiniyam 2023. You might have seen this scene in real life or in courtroom movies. A witness stands in the witness box, places their hand on the Bible or the Constitution, and solemnly promises to tell the truth. Then the lawyers begin questioning one after another, each trying to uncover or challenge the truth. Let's understand how that actually happens in real Indian courts. Oath. Before giving testimony, every witness must take an oath to speak the truth, the whole truth, and nothing but the truth. This is governed by the Oaths Act 1969. It reminds the witness of their moral and legal duty to be truthful because false testimony is punishable under law. Examination of witness. Once the oath is taken, the examination begins. As per Section 137 Indian Evidence Act 1872, which is replaced by Section 142 Bharatiya Sakshya Adhiniyam 2023, it happens in 3 stages. Examination in chief, conducted by the party who calls the witness. Purpose to obtain facts supporting their side. Leading questions, those that suggest an answer are not allowed. Example, instead of asking you were at the cafe, right, ask where were you on December 26. This ensures that the witness gives spontaneous, unbiased answers. Cross-examination. Now comes the other side, the opposing lawyer. This is the dramatic part we often see in films. Rapid questions, sharp tone, trying to break inconsistencies. Purpose to test the accuracy, truth, and credibility of the witness. Leading questions are allowed here. Forensic experts too may face such cross questions to check the reliability of their reports and conclusions. Re-examination. After cross-examination, the original lawyer can again question the witness. only to clarify or explain points that were misunderstood during cross examination. This is also called redirect examination. Hostile witness. Sometimes a witness suddenly changes their statement or goes against the side that called them. Such a person is called a hostile witness, also known as adverse or unfavorable witness. In such cases, the court may allow the same party to cross examine their own witness, and leading questions can be asked here, which normally isn't allowed. This helps reveal whether the witness is lying, confused, or has been influenced. Conduct money. Whenever a witness, especially an expert witness like forensic scientist, is summoned to court, they are entitled to conduct money. This amount covers travel, accommodation, and expenses related to appearing in court. It ensures that experts can attend without facing financial loss. Relevance for forensic expert. As forensic expert, we often appear as expert witnesses in court. So, understanding examination stages, the importance of unbiased testimony, and proper evidence presentation is crucial. So, next time you see a courtroom scene, remember every objection, Your Honor, has a deep legal and procedural meaning behind it. Let's quick recap. India has a three-tier judicial structure: Supreme Court, High Court, and Subordinate Court. Supreme Court, apex body, file interpreter of Constitution. High Courts, 25 in total, supervise all subordinate courts. District and subordinate courts handle local, civil, criminal, and revenue cases. Jurisdiction defines authority, territorial, pecuniary, and subject matter. Court procedures include examination in chief, cross, and re-examination under Evidence Act or BSA. Witness take an oath and may receive conduct money. Hope this session helped you understand how courts operate and how forensic experts fit into the legal framework. In the next lecture, we will discuss laws related to forensic science, covering IPC, CRPC, IEA, and the new BNS, BNSS, and BSA. Until then, keep learning, keep decoding.